The next time you open your retirement account, the number that may matter most is not just your balance. It may be the fee buried inside the plan. A unanimous 9-0 Supreme Court ruling has now made it easier for workers and retirees to challenge certain retirement plan transactions in court. In the Cornell case, employees alleged their plans were paying roughly $115 to $200 per participant for record-keeping services, when they argued a reasonable figure was closer to $35. The court did not order new checks, and it did not raise Social Security, but it did change the legal rules in a way that could affect retirement plans nationwide. So here is the real question tonight. If your future income depends on a 401k, a 403b, or another workplace retirement plan, could this ruling put new pressure on the people managing that money in your state? What this is about, in plain English, is not a brand new benefit program. It is a Supreme Court case called Cunningham v. Cornell University, decided on April 17, 2025. The court ruled unanimously that when people sue under a specific ERISA prohibited transaction rule, they do not have to prove at the very beginning that every possible exemption fails. Instead, the retirement plan fiduciaries and other defendants have to raise those exemptions as defenses. That sounds technical, and it is technical, but technical rulings often have very real consequences because they determine which cases get dismissed quickly and which cases move forward into discovery, legal costs, and possible settlements. Before we go any further, let me make one point absolutely clear, because this is where a lot of online confusion starts. This ruling does not create a new monthly payment. It does not approve a bonus for seniors. It does not change the Social Security cost of living adjustment, and it does not mean that retirees automatically receive money because the Supreme Court ruled 9-0. What it does is change the pleading standard in a type of retirement plan lawsuit under ERISA, the federal law that sets minimum standards for many private sector retirement plans. Here is why that matters to people over 45, retirees, and anyone close to drawing more heavily on retirement savings. For many Americans, especially those no longer adding large new contributions, hidden plan costs matter more than ever. A difference in fees over time can reduce long-term growth, and once you are retired, those expenses can continue to eat into what you have left. So even though this case is not about Social Security, it is about something many viewers depend on alongside Social Security: employer-sponsored retirement savings. If your plan pays more than it should for administration, record-keeping, or other services, that affects the money available to you over time. The facts of the Cornell case help explain the issue. According to the court record, Cornell administered 2 defined contribution retirement plans with more than 30,000 participants and nearly $3.4 billion in combined net assets. The plaintiffs alleged that the plans paid Fidelity and TIAA substantially more than reasonable record-keeping fees. The Supreme Court was not deciding whether Cornell ultimately did anything wrong. The justices were deciding something narrower but still important: what plaintiffs have to say in a complaint in order to get that kind of claim into court. And the answer from the court was clear. To state a claim under that ERISA provision, plaintiffs only need to plausibly allege the elements listed in the statute itself: that a fiduciary caused the plan to engage in a transaction for services with a party in interest. They do not have to plead, right up front, that the transaction fails every exemption in a different section of the law. The justices said those exemptions function as affirmative defenses, which means the defendants must raise and prove them. That is the rule change. And the reason people are saying this could change retirement plans in every state is because the Supreme Court settles the legal standard nationwide. SCOTUS blog noted that lower courts had been handling this issue differently, and the ruling now provides one federal rule for ERISA pleading in these cases. In other words, a participant in one state and a participant in another state should no longer face different threshold rules on this question just because different federal circuits used different approaches before. Now, who is actually affected by this and who is not? This part is important. ERISA generally applies to retirement plans in private industry. The Department of Labor says federal, state, and local government plans, along with some church plans, are not covered by ERISA. So, if you are receiving Social Security, this ruling does not directly change your Social Security benefit. If you are in a public employee pension run by a state or local government, this case does not automatically govern that plan the same way. But if you participated in a private sector 401k, a private employer pension, or certain 403b arrangements covered by ERISA, then this decision is much more relevant to you. That distinction is critical because a lot of online videos blur these categories together. They hear retirement, Supreme Court, and 9-0, and suddenly the story becomes all seniors are getting money. That is not what the opinion says. What the opinion says is that one type of ERISA lawsuit now clears the first hurdle more easily than before because plaintiffs do not have to negate the exemptions before the defendants even identify which exemption they intend to rely on. If you have ever looked at your account statement and wondered why the growth feels slower than expected, have you checked whether fees inside the plan are part of that story? Why would this matter to retirees who are no longer working? Because retirement plan costs do not always stop mattering once paychecks stop. Many retirees leave money in an employer plan for years. Others roll funds into an IRA only after paying years of plan expenses. And many people between ages 55 and 70 are in the most sensitive period of retirement planning, where fees, distribution timing, and market performance all carry more weight. This ruling will not change your account overnight, but it could increase scrutiny on plan sponsors, service provider contracts, and internal documentation about whether fees are reasonable and services are necessary. There is also another side to this story, and it matters for balance. The court acknowledged concerns about opening the door to weak lawsuits. SCOTUS blog explained that the justices recognized the threshold could be low, but they pointed to tools lower courts can still use to manage meritless cases, including requiring more specific replies, dismissing cases with no real injury, and using sanctions where appropriate. So, this is not the Supreme Court saying every plan sponsor did something wrong. It is the Supreme Court saying the statute places the burden of raising exemptions on the defendant side, not the participant side. In just a moment, I'll explain what would actually need to happen before any payments are sent, any fees are lowered, or any retirement plan changes show up in the real world. First, understand the immediate consequence. The ruling mainly changes what happens at the start of a lawsuit. It means more cases may survive motions to dismiss and move into discovery. That matters because discovery is expensive, time-consuming, and often uncomfortable for employers, fiduciary committees, and service providers. Once a case gets that far, some organizations may review their plan practices more aggressively, renegotiate fees, improve documentation, or settle certain disputes rather than fight all the way through years of litigation. That does not mean everyone wins money. It means the pressure point moves earlier. Analysis from the retirement industry after the decision said plan sponsors may now focus even more on documenting fiduciary processes, benchmarking fees, reviewing vendor relationships, and maintaining strong committee minutes. In simple terms, the safest plans will likely be the ones that can show, on paper, why they chose a provider, what they paid, how they compared alternatives, and how they monitored those decisions over time. So what would actually have to happen before any participant sees money? Several steps. A case would still need to proceed through lower courts or settlement discussions. Plaintiffs would need to prove their claims or negotiate a settlement. A court or settlement administrator would need to determine who is included, what losses, if any, occurred, and how any recovery would be distributed. In many cases, that takes months or years, not weeks. And in some cases, participants may never receive direct payments at all, even if the result is simply lower fees going forward or changes in plan governance. That is why it is so important not to confuse a legal ruling with a payout announcement. If you are already retired, ask yourself this: is your money still sitting in an old employer plan? And if so, do you know what that plan is charging today? Here is the practical timeline viewers should keep in mind. The Supreme Court ruling is already effective as precedent, meaning lower courts now have guidance on this legal question. but the practical impact unfolds slowly. Plan sponsors may start internal reviews right away. Lawyers may file or revive more ERISA claims. Some plans may adjust record-keeping arrangements or document their oversight more carefully over the next review cycle. Participants, however, should not expect a letter next month promising new compensation just because of this opinion. The legal system does not move that fast, and the ruling itself did not award damages. For viewers who want to know what to do right now, the answer is calm and practical. First, do not panic. Second, do not fall for rumors claiming the Supreme Court approved a new retirement payment for all seniors. Third, if you still hold money in a workplace plan, review the fee disclosures and plan notices available through your account portal or benefits office. Look for administrative fees, record-keeping charges, investment expense ratios, and any advisory or managed account fees. If you are not sure what type of plan you have, ask whether it is covered by ERISA. That one question can tell you whether this case is even directly relevant to your account. If you are still working, this is a good time to pay attention to any notices about plan changes, vendor changes, or fee disclosures. If you are retired but still in a former employer plan, review whether that plan remains the best place for your money. I am not giving individual financial advice here, and any rollover decision should be made carefully, with taxes, investment options, and protections in mind. But awareness matters. Many people watch market headlines and miss the smaller costs that quietly shape retirement outcomes year after year. Another point that deserves attention is qualification. People sometimes hear the phrase, beneficiaries sued, and assume everyone receiving any benefit qualifies to join a case. Not necessarily. Eligibility in any future lawsuit or settlement would depend on the plan involved, the time period involved, and whether a person was a participant during the relevant period. That is one more reason you should ignore blanket claims online that all retirees now qualify. That kind of statement is far too broad and usually wrong. And here is the broader reason this case matters even beyond Cornell. When the Supreme Court speaks unanimously on a rule affecting private retirement plan litigation, employers, plan committees, record keepers, lawyers, and consultants all pay attention. Some may tighten oversight, some may benchmark fees more often, some may change how they document decisions. Those are not dramatic headline changes, but they are exactly the kinds of behind-the-scenes adjustments that can shape retirement plans in every state over time. Do you think most workers are given enough clear information about the fees inside their retirement plans? Or do those costs stay too hidden until it is too late? So let's bring this all together in simple language. A 9-0 Supreme Court ruling did happen. It involved retirement plans. It could have nationwide effects because it sets one federal standard under ERISA. The case makes it easier for plaintiffs to get a certain kind of retirement plan claim past the opening stage of litigation. But it does not create a new Social Security benefit. It does not send automatic payments to seniors, and it does not mean every retiree qualifies for money. What it may do is increase pressure on private sector retirement plans to justify fees, monitor service providers carefully, and keep better records of how decisions are made. That is the key takeaway tonight. The ruling is real. The 9-0 vote is real. The nationwide legal impact is real. But the rumors about instant payouts are not supported by the decision itself. If you stay focused on verified information, the story becomes much clearer and much less alarming.